Good morning, everybody. As advertised, this is the first in a new series of updating webinars in which members of Maitland Chambers will be discussing recent key developments in the property litigation world. And if you have any questions, please do just put them in the chat function. And if there's time at the end, then we'll do our best to answer them. The order is going to be me, that's Tim Harry, then Adam Smith, and then last but not least, Michael Pryor. So it is my pleasure to welcome you this morning and to give my contribution, which is to deal with the decision in Lazari Properties and New Look in the context of company voluntary arrangements, or CVAs. Because it followed shortly thereafter and was decided by the same judge, that's Mr. Justice Zaccaroli, and also in the context of CVAs, I'll also say something about the recent Regis decision as well. Now, I think it's fair to say that New Look has attracted a lot of adverse comments. And the heading in the Estates Gazette was High Court rulings promise a world of hurt, above which there is a picture of a weightlifter lifting his weights, whatever the significance that may be. The opening sentence is outrageous, demonized, dangerous precedent, world of hurt. And this was the quote in the article from the chief executive of the British Property Federation. The government must ensure clarity and fairness. Property owners do not want to see businesses go into administration, but preventing administration should not mean property owners are forced to absorb a disproportionate amount of pain compared to other creditors. So I know many of you will be familiar with CVAs, but for those who are not, then in summary, the aim of a CVA is to offer some or all creditors a compromise which allows the company to avoid administration or liquidation, and in doing so, produce a better outcome for all creditors. A licensed insolvency practitioner will be instructed by the company to formulate the CVA, which is then filed at court before being distributed to creditors. To be approved, 75% of creditors by value must vote in favour of the proposal. If it is approved, it becomes binding on all creditors, whether or not they voted in favour of it. And there is just one meeting for this purpose. So in theory, at least, a pretty simple process. Creditors vote as a whole rather than by class. So even if the CVA only compromises the rights of one group of creditors, such as landlords, all creditors can vote for the purpose of assessing whether the requisite majority is obtained. The principal grounds for challenging a CVA is that there has been a material irregularity in the process or unfair prejudice. Now, in New Look, landlords, including Land Securities and British Land, together with the new owners of Manchester's Trafford Centre, challenged New Look's use of a CVA to reset its rents for the second time in 3 years and to write off rent arrears. The immediate reason for the CVA was COVID. At the start of the first lockdown, the group's revenue fell to nil and stores were closed again as a result of the second and third lockdown. Almost 2/5 of the landlords voted against the proposals, but the CVA still proceeded because other unsecured creditors voted in favour. The judgment is long and detailed, 61 pages and 330 paragraphs, so I'll not, you'll be glad to hear, cover all of the arguments. The principal ones were these. First, it was said by the landlords that the proposal was part of a wider financial restructuring that also involved bondholders who were treated differently, and so the scheme fell outside the CVA jurisdiction in any event. In other words, there were 3 substantially different deals with 3 classes of creditors, and that was said to be an impermissible use of a CVA. The judge differed and determined that a CVA which provides a different treatment of different subgroups of creditors is not outside the jurisdictional scope of a CVA. Second, it was said that there was a material irregularity because, amongst other things, there had been an incorrect valuation of voting rights and there had been inaccuracies in the proposal. For these purposes, a material irregularity is largely a question of some failure to comply with the process, such as failing to disclose relevant facts to creditors and flaws in giving them notice to creditors and the conduct of the procedure. But here the judge found that there was no such irregularity. So far as information was concerned, he said that sufficient information must be given to creditors to reach an informed decision, and that had been done here. Third, and this is perhaps the most controversial aspect, he found that there was no unfair prejudice. To set aside a CVA on the grounds of unfair prejudice, a creditor must show that the CVA is not only prejudicial to its interests, and most will be prejudicial by their very nature, but also that the prejudice suffered by the creditor or class of creditors is unfair. So what is the test for unfairness? The courts will look at two aspects, one called horizontal fairness and the other vertical fairness. Horizontal fairness is whether a creditor or class of creditors has been treated less favorably compared with other creditors in a comparable position. Vertical fairness is whether creditors are going to be in a better position than they would be in the event of the company's liquidation or administration. If they are not going to be in a better position, then that may well be unfair. But importantly, the mere fact that there is a differential treatment does not by itself establish unfair prejudice. Rather, it gives cause for inquiry, and that differential treatment must be justified if it is not to be unfair. And the judge expressly said that differential treatment of creditors might be essential to the rescue of the business. So, example, where payment in full of suppliers is needed to ensure business continuity. I should say that one of the difficulties here is the law is principally judge-made. The CVA regime was introduced by the Insolvency Act 1986 as a result of recommendations made by the Cork report, which was chaired by Sir Kenneth Cork, possibly the leading insolvency practitioner of his day and sometimes known as the insolvency baron. On one reading of the report, its authors might have been contemplating that the CVA process was only intended to be used in simple cases. There is no statutory provision, for example, dealing with how leases or rents are to be treated. But at the end of the day, the judge said that whether unfair prejudice exists depends upon all the circumstances. Amongst other things, he said that it would require consideration of whether there is a fair allocation of the assets available within the CVA between the compromised creditors and other subgroups of creditors, the nature and extent of the different treatment and the justification for that treatment, and whether others in the same position as the objecting creditors approved the CVA. These are non-exhaustive considerations, and the judge acknowledged that it was a difficult concept to pin down. So this is all very general and fluid on the facts, and he found there that there was no unfair prejudice. So there are particular aspects of the finding which I would draw to your attention. First, it was argued by the landlords that a CVA cannot operate to reduce future rent while permitting the tenant company to remain in possession, because that was inherently unfair. But the judge, following the decision in Debenhams in 2019, rejected that argument. There, Mr. Justice Norris accepted that the very right to terminate the leases would in principle eliminate any unfairness. And one thing which you cannot remove by a CVA is a right of forfeiture. However, just to be clear, and this is something I know which landlords resent, the right of forfeiture can only be exercised in relation to the pecuniary obligation, the rent, in other words, which has been modified by the CVA. Second, the judge accepted that a tenant could not force a landlord to accept a surrender as part of a CVA because it would interfere with the proprietary rights of a landlord. However, for some landlords, their rent was to be compromised in full, and after 2 months of rent at a contractual rate, they would cease to be entitled to any rent or service charge. The landlords contended that this operated in substance as a surrender, but the judge disagreed. The proposal, he thought, offered the landlords the opportunity to agree to a surrender of the lease, but did not require them to do so. I can see myself as a matter of principle that the removal of the obligation to pay rent does not itself work as surrender, but in the practical terms, I can also see the landlord's argument that it may be left with no choice but to accept a surrender. And third, it was argued that a CVA could only escape a finding of unfair prejudice if at least market rent was paid. But again, this argument was rejected. The judge thought that a permanent or long-term reduction in rent imposed on landlords without the option to terminate might be inherently unfairly prejudicial, but it was the option to terminate which prevented the unfairness. That was the counterbalance. Now, having said all that I have said, my understanding is that the New Look CVA landlords have been granted permission to appeal the High Court's decision or rejection of their challenge. And so one can confidently expect these arguments to be ventilated again. I said that I'd also deal with the same judge's decision in Regis, Regis being the chain of hairdressers and beauty salons. That matter was argued over 7 days. At one level, it's curious because although the CVA was challenged and an order sought revoking the CVA, it had actually already come to an end on the 23rd of October 2019 when the company went into administration. However, the claim continued against the nominees, that is, those entrusted with implementing the CVA, for an order that they repay their fees, which amounted to £15,000 in their role as nominees and £30,000 in their role as supervisors. And there was also a question of costs. However, the decision is of some interest in that the CVA was revoked on the grounds, on a very narrow ground, that there was unfair prejudice. And the narrow ground was this. It was the case that Regis owed a debt of nearly £600,000 to its shareholder, International Beauty Limited, IBL. And under the CVA, this was going to be repaid in full, while all impaired creditors under the CVA, including landlords, were only to be paid £330,000, a fraction of their claim, just 77%. But for the CVA, IBL would have recovered nothing. So their preferential treatment was determined to be unfairly prejudicial. This potentially did have a consequence for the nominees because it was said that they were in breach of their obligations to consider the proposal and make such inquiries as they considered necessary to satisfy themselves that the proposal ought to be put to creditors. There was no evidence that the nominees made any attempt to question with IBL or Regis the propriety of IBL being paid in full, notwithstanding numerous factors which suggested that it would be unfair to the compromised landlords. So what was the upshot? The judge considered he did have jurisdiction to make an order that the nominees repay their fees, but at the end of the day, he didn't think it was appropriate to do so in circumstances where the services provided by them had not been valueless. Finally, I'm conscious that I've not dealt with a decision in Virgin Active dealing with the new cross-class cram-down arrangements, which now form Part 26A of the Companies Act 2006, or indeed with schemes of arrangement generally. But our intention is to do this in a separate webinar in due course, when we'll also consider the 2015 EU recast regulation on insolvency proceedings. And you may know that because of the Brexit withdrawal agreement, this still has effect in relation to cross-border insolvencies and still has relevance to the termination of tenancies in an insolvency situation where there is a cross-border element with leases in various EU jurisdictions. But we will deal with that in due course. So now I am going to hand you over to Adam, who is going to deal with the decision of Master Dagenham on covering getting judgment in a COVID world, and also with a slightly more arcane area of the Reverter Sites Act. It was a matter which went to the Supreme Court recently, a couple of members of our chambers on opposing side. And indeed, Master Dagenham was, until about a year ago, one of our colleagues, known well for his very lengthy opinions and very learned opinions, and also his complex pleadings. So I myself will be interested to know what Adam has to say about this judgment of Master Dagenham.
Thanks very much, Tim. I'm going to try to use some PowerPoint, so I hope that those have come up on screen now, but I think they have. So firstly, as Tim said, I'm going to discuss, as the first case, the Bank of New York Mellon International Limited and Cine-UK Ltd and conjoined cases. This is a decision on an application by landlords for summary judgment in 3 conjoined claims for rent arrears in relation to commercial premises, which were cinema, bingo hall and the Sports Direct shop. The claims were defended by the tenants on the basis of matters related to the COVID-19 pandemic. Under the COVID-19 regulations, the demised premises could not be entered by the public for substantial periods of time, and the rent arrears related to these periods. Defences were raised based on the pandemic, and they were all ultimately rejected by the court. As Tim said, it's a decision of a master, not Master Dagenham, our former colleague, and therefore its value as precedent is obviously limited. Nonetheless, we suggest it's worth considering in a little detail. First, as Tim highlighted, it is actually a fairly impressive judgment and impressively reasoned. And secondly, it deals comprehensively with arguments which might be thought to be run by tenants in this context, with the leases at issue being in fairly standard form, and therefore arguments in many other cases are likely to be similar. It is a very lengthy decision. It's about 97 pages or so. So what I'll aim to do is provide a summary only of the key issues raised and the rulings on them. On the next PowerPoint, I'll try to get that up now. Yes, there we are. I've given a broad summary of the defences raised, and I'm going to run through these in order. It is by way of further background, noting that a few days prior to the handing down of this judgment, there's also another master's decision of Chief Master Marsh in a similar case, which is Commerce Real and TFS Stores Limited. In that case, the Chief Master also rejected COVID-19 defences to a landlord's claim for commercial rent arrears. However, the matters were dealt with in that case substantially more shortly than in this one, less comprehensively, and therefore it's more useful to focus upon the bony case for the purposes of this webinar. So the first point is the express terms of rent cessor clauses in the various leases. The relevant leases all contain similar, fairly standard rent cessor clauses, providing for payment of rent to be suspended in certain circumstances. And I've set out one of them on the next slide in the PowerPoint, just for ease of reference and by way of example, they're in fairly similar form. The tenants argued that the words damaged in each of the rent cessor clauses referred not only to physical damage, but also to what one might term metaphorical damage. For example, as in the phrase, the premises have been damaged by a road closure. It's fair to comment this is quite an ambitious contention in the light of the wording of the clauses, and indeed in the light of the generally understood effect of standard rent cessor clauses, such as those in issue, i.e. that what those clauses are concerned with is physical damage to the premises only. The master disposed of this contention in fairly convincing terms. His key reasoning is likely to arise from the wording of many rent cessor clauses, and it's therefore worth considering it in a little detail. First, he held that the usual meaning of the word damage is physical damage, and I don't think anybody would particularly disagree with that. Second, he noted that for many years it has been open, as a matter of fact, to tenants to take out business interruption insurance in respect of their trade. That context, the master held, supports the position that there's nothing commercially unreasonable in the rent cessor clauses being confined to physical damage. In other words, the tenant's way forward in such a situation is to take out business interruption insurance to avoid the problem where they end up holding premises and paying rent for them, which they're not able to use. And third, he noted that, as will often be the case, particular provisions of the rent cessor clauses, in particular as to application of insurance monies and reinstatement, were suggested of the clauses being concerned with physical damage only. As an alternative argument, the tenants claimed it as an implied term in each of the leases, to the effect that the rent ceases to be payable in circumstances such as those arising under the COVID-19 regulations. This is also a fairly ambitious argument, I think it's fair to say, and the master disposed of it in robust terms, applying a traditional approach of considering whether suggested implied terms were obvious or necessary. Again, his reasoning is likely to be applicable to any standard commercial lease and is therefore worth dwelling on briefly. First, the master noted that, in the usual way, the leases were drafted in detailed terms. He, unsurprisingly, it suggested, took from this that the parties intended the express terms of the leases to cover the entire legal relationship between them. Second, he held that the inclusion of the express provisions as to rent cessor was a strong factor against the implication of a term providing for rent cessor in different circumstances, i.e. he reasoned that the express provisions indicated that where the parties intended there to be a rent cessor, then they provided for it expressly. Third, he noted that none of the leases contained any landlord's warranty that the premises could be used for the permitted use. The master viewed this, it suggested correctly, as an indication that the parties intended that any risk that the premises could not be used for the permitted use was to be borne by the tenants. Next, the master noted that in previous cases, the courts have held that rent remains payable, even where the premises become physically unusable, for example, by cause of fire. And therefore that those cases indicate that the relationship of landlord and tenant itself does not give rise to an implication that rent should cease to be payable if the premises become unusable. The master correctly, it suggested, reasoned that it's hard to see why the position should be different if the impossibility of use plays in legislation, as opposed to a physical circumstance. Finally, the master did not consider it to be commercially nonsensical for rent to remain payable in the circumstances, but to the contrary held this to be a reasonable allocation of risk. The master noted again that the tenants could have taken out business interruption insurance to protect themselves in the present circumstances. And again, it suggests that this is compelling reasoning. The tenants also took a number of points based on the insurance position under the leases. The key background here was that the landlords had taken out insurance in respect to the premises, which insured them for loss of rent caused the master held by COVID-19. The policies at issue were, it appears, standard policies, and this is therefore likely, it seems, to be the position in many cases. In the usual way, under each of the leases, the tenant was obliged to reimburse to the landlord the cost of the insurance, and the tenant's interests were noted on the policies. In these circumstances, the tenants first argued that, 1, the unpaid rent was recoverable by the landlords under the insurance policies, and 2, the tenants were entitled to take advantage of this insurance, and accordingly were not obliged themselves to pay the rent. Importantly, the master, this is at paragraph 158 of the judgment, appears to have accepted, in the light of authority in somewhat different contexts, the second limit of this argument, i.e. he was persuaded that if the rent was indeed covered by the insurance, then as a matter of law, the tenants were entitled to withhold payment of the rent and insist that the landlord recovered the rent from the insurer. However, the master rejected the first limit of the argument, i.e. he held that on a true understanding of the insurance policies, the insurers were not liable for the unpaid rent in the circumstances. This will also, it's thought, be of potential relevant to other cases, given the standard nature of the insurance policy at issue. The critical point in the master's reasoning, which again is likely to be generally applicable, is that the policy insured expressly against loss of rent, and that rent is not lost to a landlord where it remains payable by the tenant. Again, it suggests that the master's reasoning here is correct. The tenant secondly argued in relation to insurance that because the landlords had taken out insurance which had the effect of including the COVID-19 pandemic as an insured risk, then under the terms of the leases, the landlords were obliged to insure for payment of the rent if this insured risk eventuated, as it had. And the landlords were accordingly, it was claimed, in breach of covenant for having failed to do so. Although not spelled out in the judgment, The tenant's point here seems to have been that the landlords were in some sense relying upon their own wrong and suing for the rent arrears in these circumstances. The master rejected the contention that the landlords were under any obligation to take out insurance to this effect. Given the standard nature of the insurance policies and of the relevant leases, the master's reasoning here again is likely to be relevant to a similar argument in another case. The master's key reasoning here was, first, the express language of the leases referred to insurance against loss of rent. This meant the master held actual loss, for example, where the tenant is not liable for rent as a result of the operation of a rent cessor clause. Second, there's nothing commercially nonsensical in the landlords not being under the alleged obligation. Again, it was open to the tenants to take out business interruption insurance themselves to protect against the present risk. And the insurance required under each lease was primarily for the benefit of the landlord, not the tenant, with the tenant being required to pay for it simply as part of the consideration for the grant of the lease. Again, it suggests that the master's reasoning here is compelling. The master next dealt with frustration. By way of general background here, it will be recalled that it's now well established that the doctrine of frustration is capable of applying to leases. That was decided by the House of Lords in the National Carers and Palpina case in the early 80s. Various tests of frustration have over time been put forward in the authorities. The test, which I think it's fair to say is now generally favoured, is that frustration may occur where something happens after the formation of the contract, which renders the performance of the bargain under the contract radically different when compared to the position at the time that the contract was concluded. In this case, it was not seriously argued, it appears, by the tenants that the leases had been discharged by frustration. However, the master helpfully addressed the question in a little detail, holding that the leases had not been frustrated. It's useful briefly to look at some parts of the reasoning here, as it illustrates a notorious difficulty in successfully running a frustration argument in relation to a lease. So turning to some key points, the master first noted that there is no positive obligation as to use in any of the leases, i.e. that there is no keep open covenant. It therefore could not be said that in the light of the pandemic, any of the leases now required the tenants to do something which was illegal. The master then reasoned that relevant to a radically different test were the likely period of the COVID-19 disruption, judged at the time at which the alleged frustrating event, i.e. the enactment of the COVID-19 regulations, occurred. Second, the remaining terms of the leases at that point in time, and similarly, whether the leases were within or outside the continuation provisions of Part 2 of the 1954 Act. And third, the length of the terms of the leases when granted. Here, the maximum likely period of disruption flowing from the COVID-19 difficulties was no more, the master found, than 18 months at any point. The terms of the leases were respectively 20 years with 12.5 years to run after the end of the disruption, 15 years with 11 years still to run at that point, and thirdly, 15 years with 1 year still to run. In these circumstances, the master concluded that the likely period of the disruption, judged by reference to the expired and unexpired terms of the leases, was not sufficient to render performance of the bargain under the leases radically different. It's respectfully suggests that this was an unsurprising conclusion on these facts. With a much shorter term lease, however, a frustration argument on the basis of the COVID-19 regulations might be more compelling, and might conceivably, all other things being equal, succeed. Secondly, in relation to frustration, one of the tenants argued that its lease had been temporarily frustrated, i.e. it contended had ceased to operate simply during the period of the COVID-19 disruption. The master is able to dismiss this contention fairly shortly. He pointed out that such a doctrine has never been recognised, and held that its recognition now would be inconsistent with remarks of the House of Lords in the Palpina case, which were to the effect that extension of the law of frustration is now a matter for Parliament and not the courts. And this is convincing reasoning, I suggest. The final ground of defence which merits some comment is a point taken by the tenants to alleged supervening illegality. As to this, the master noted that it is established law that if an obligation becomes impossible legally to perform, for example, as a result of legislation enacted subsequently to the entry into the contract, then performance of the obligation is suspended until such time, if any, as it may again legally be performed. The tenants, however, argued that this doctrine extended so as to remove their liability to pay the rent. The difficulty of this argument was that there is, and was plainly, nothing illegal in the payment of the rent per se, and nor could it convincingly be said that the obligation to pay rent was in some sense conditional upon the public being able to access the premises, and the master rejected the argument accordingly. This is of course likely to be the case in all, or very nearly all cases, and it's therefore suggested it is unlikely that this doctrine will provide a successful basis of defence to a claim for rent in the circumstances of the pandemic. In summary, therefore, of perhaps the key points to take from this decision, it is suggested that those are, one, at least in the substantial majority of cases, the only hope of resisting a liability for rent on the basis of the pandemic is likely to be a contention that the lease has been discharged on the basis of by frustration, and two, that doctrine will provide an escape route for a tenant only in fairly rare circumstances, if at all. The second case I'm going to be discussing, as Tim mentioned, is the decision of the Supreme Court in Ritz and Thomas and Oxfordshire County Council. This is a decision in relation to an alleged statutory reversion of a freehold estate, which was at the site of a school. Statutory reversion may fairly be described as quite a niche area, but one does sometimes, in practice, come across issues of statutory reverter, and it's therefore worth having an awareness of the case for that reason, I suggest. And further, and more generally, the Supreme Court took the opportunity in its judgment on the case to set out some points as to the correct interpretation of certain types of statute. It's first helpful briefly to consider the background. There's a series of Victorian statutes under which persons are enabled to transfer land under a statutory charitable trust, and pursuant to which, by the statute, the land is to revert to them or their estates and heirs if, broadly, at any time the land ceases to be used for the purposes of the statutory trust. These statutes are the School Sites Act, which relate to gift of land for purposes of a school. Second, the Literary and Scientific Institutions Act, which is concerned with gifts for the purposes of broadly libraries and museums. And third, the purposes of worship, the Places of Worship Sites Act 1873, i.e. land devoted for chapel, church, residence of priests, of a priest, and so on and so forth. Under Reversion of Sites Act 1987, these acts were amended so that if a reverter is triggered, the land does not per se revert, but simply becomes held on the trust for the benefit of the persons to whom the land previously would have reverted. It is, however, convenient to still use the word reverter to describe this process, and that's the sense in which I'm using the word here. Turning next to the facts of Ritz and Thomas, the case concerned a school constructed on land given under the School Sites Act 1841. The local authority decided to relocate the school to a new site and to sell the existing site to help pay for the new school premises. The timing here is important. First, the new premises were built and the school moved into the new premises when they're completed. And then second, after approximately a year after marketing, the original site was sold. Plainly, in many cases, this is likely to be the most practical, possibly even the only practical way of organising a move of an institution from existing premises, set of premises to new premises. The decision in the case hinged on the proper construction of sections 2 and 10 of the School Sites Act. Under section 2 of the Act, if land ceases to be used for the statutory purpose, then a reverter is triggered. And under section 14, there's power under the charitable trust created by the statute to sell the land and to apply the proceeds of the sale in the purchase or improvement of another school site. Unsurprisingly, it was common ground between the parties that on the proper construction of the Act, the power under section 14 cannot be exercised after the reverter has been triggered. The local authority contended that the reverter had not been triggered, and therefore, when it sold the land, it did so in exercise of the section 14 power, and it was entitled, pursuant to section 14, to apply the proceeds of the sale in paying costs of the new school premises. Persons entitled under the estate as the donors of the school of the land argued by contrast that the reverter was triggered the moment the land was vacated by the school. And therefore, because the sale of the land took place only after then, the sale cannot have been effected under the Section 14 power, and therefore they're entitled to the proceeds of sale. So it was, I think it's fair to say, a rather technical position adopted by them. The Supreme Court decided in favour of the local authority. It held that within the meaning of Section 2, the land continued to be used for the purposes of the school, even after the school had vacated the land, in the circumstance that the land was being sold to raise money to pay for the new school premises. It's fair to say that this is not the most natural interpretation of the language of Section 2, although obviously this interpretation led to the more attractive results on the facts of the case. Turning finally to the Supreme Court's approach to construction, it held first, because the underlying purpose of the gift under the statute is charitable, the court should take a broad and practical approach to the interpretations of the reverted provisions in the Section 14 power, which leans in favour of the continuation of the charitable trust. This reasoning will apply to the construction of each of the statutes to which I've referred, I suggest. Second, it held that, in general, the court should adopt a broad approach to the interpretation of pre-1869 statutes. The significance of the 1869 date is that this is when the office of the Parliamentary Council was created, from which point on, a more rigorous style of drafting was adopted, which naturally invites closer attention to be paid to precise language used in a statute. This is, it seems, an approach of general application, which is the Supreme Court has indicated should be adopted in construing older statutes, i.e. pre-1869 statutes. Third, and finally, the Supreme Court re-emphasised the modern approach, that in general courts should adopt a purposive approach to statute construction where possible, and therefore that individual provisions should be construed in the context of the statute as a whole, and importantly, the historical context. This is a useful reminder. There is, however, of course, a limit to this approach, in that the court will not give to a statute a meaning which it does not decide as a possible interpretation of the language used. So those are the key points I suggest from the Ritz and Thomas case, and I'll now hand over to Michael for the final part of today's webinar.
Good morning, everyone. I'm going to talk chiefly about the case of Barking and Dagenham and Persons Unknown. It's the recently decided Travellers injunction case. What was happening was that a cottage industry had developed in which local authorities were seeking traveller injunctions against persons unknown. And this was preventing travellers moving onto sites. The problem from their point of view was obvious. Travellers would come on, and by the time they could be removed, they'd either caused damage or they'd infuriated council taxpayers. Local authorities were getting injunctions against persons unknown that was covering all the potential sites in their borough. Many would have pointed out that this was in contrast to the enthusiasm for complying with their duty to provide sites, but that's another point. Mr. Justice Nicklin put a spanner in the works of this scheme. And in 2020, the courts gathered together at what they called a cohort of 38 of these cases, and they were assembled to be managed together in the Queen's Bench Division. This led to the hearing before Nicklin, and what he did was he looked at 4 particular issues which were of general importance and which resolved all the cases. And I'll just identify what those are before coming to them later. First was whether the court could reconsider any final orders made against persons unknown. Because everyone knows that normally a final order merges into the cause of action and it can't be challenged, can't be tinkered about with by the parties. That's that. So that's the first issue. The most significant and important one that I want to concentrate on is whether the court could make final orders against persons unknown, which would bind newcomers. So this is an order which on its terms would deal not just with the people on the site at the time that it was made, but it would stop anyone coming onto the site afterwards. The practical utility of this from the local authorities' point of view is obvious. You don't have to keep on issuing fresh proceedings and chasing people whose names you don't know. You've got your order, you've protected the site, and you can prevent further trespass. So can you have final orders against persons unknown which binds newcomers? And if you can't, can you have what are called contra mundum orders, which are orders against the whole world? Those are the key issues, and they turn on fundamental and relatively straightforward aspects of civil procedure. There were two other issues which were parasitic upon those. Did you need to ascertain who the parties were to any final orders? And what Mr. Justice Nicklin called the conundrum of interim relief, which I'll return to. Now, before he tackled those issues, Mr. Justice Nicklin, in what was a very long and impressive judgment, analysed and quoted at length from three key decisions from which he got his fundamental principles, and he identified the factors of the cases before him which caused him concern.
So if I can just intervene, Michael, what were those three cases?
Well, the three decisions before were, the first one was a case called Cameron and Liverpool Victoria Insurance. And this, believe it or not, was a road traffic claim. It was decided in the Supreme Court. And what happened in that case was that the claimant was in a car accident. She wasn't able to identify the driver at fault. So the person she sued was described as the person unknown driving the other vehicle who collided with mine. Now, her claim was dismissed. And I'm going to quote from Mr. Justice Nicklin's summary of the reasons here. He said, the fundamental principle of justice that a person could not be made subject to the jurisdiction of the court without having such notice of the proceedings as to enable him to be heard was breached. So by naming someone in that way, you couldn't get them before the court. So the fundamental need to get them before the court was not complied with. Now, Mr. Justice Nicklin looked at this decision. He identified 15 key principles from Lord Sumption's judgment, which he called the Cameron principles, and I'm only going to refer to three of them of particular importance. And the first is, again, it's a fundamental principle that we're all familiar with. Courts act in personam, that individuals, they resolve disputes between litigants, so that proceedings are only completely constituted once the defendant, who the claimant wishes to get before the court, has been served. This is a little bit like possession cases that we'll be familiar with. Courts don't declare title to the world, but they decide who has the better title between the parties in front of them. That's Aster and Whitlock. So this is fundamentally how our litigation system works. You have two parties against one another. They need to be before the court, and the court decides who the winner is. So that's the first fundamental principle. The second is that there are two distinct categories of defendants who cannot be named. There's ones who can be identified and described, but not named. So squatters on a particular bit of land, you might say the man on the site down the street, that person can be identified and communicated with. But defendants who cannot be described in a way which enables one to communicate with them are different. And that might be the man who stole my iPhone, or as happened in Cameron, the person who drove into me. You can't identify them, you can't bring them before the court, you can't sue them. Now, Cameron did identify a difference between interim relief, which can be granted against persons unknown, and final relief. Interim relief, as we know, is designed to preserve the position, it's provisional, it's conditional, and by definition, it's going to be reviewed later. So those three core principles, they find themselves being repeated and buttressing Mr. Justice Nicklin's fundamental decision. So another decision that he referred to is called Bromley LBC and Persons Unknown. And this was a traveller's injunction case, much closer to the one before Mr. Justice Nicklin. In that case, the local authority tried to get a queer timet, as we all know, an anticipatory trespass injunction against persons unknown. So they wanted an order to stop persons unknown possibly coming onto a site. That application was rejected and the Court of Appeal upheld the rejection. And there's two aspects of the decision I'd like to refer to that Mr. Justice Nicklin referred to. The first is that the Court of Appeal identified the necessary elements for a queer timet injunction. And they are, there must be a real and imminent risk of commission of a tort. it must be impossible to name the persons who are likely to do it. That's why you have to say persons unknown. It must be possible to give them notice of the injunction. That's the distinction between the man who stole my iPhone, the man who's round the corner. And the terms of the injunction have to be precise and tightly limited. So it has to be restricted to a wrong. You can't prohibit lawful conduct by an overwide injunction. And it must have clear geographic and temporal limits. So it must be this area for this time. The Court of Appeal also pointed out that Article 8 is engaged because the traveller community, when they pitch up at a site, it's their home. So the need to respect family life and so on and so forth is engaged. Issues of proportionality are crucial. They arise, and that can include putting into the balance the local authority's duty to provide sites in the area. Are they doing that, or are they in fact harrying travellers all over the place with borough-wide injunctions? And in that case, the injunction was refused largely on the grounds of proportionality. All the elements that I've described earlier were met, such as risk of a tort, impossible to name persons, and so on. Those were met, but it was disproportionate. And the third case Mr. Justice Nicklin referred to was yet another different sort of case, and this was a protester's case called Canada Goose. And Canada Goose, as you probably know, make clothes which include animal fur and down, and their shops are subjected to protesters outside. They wanted to get an injunction to stop this. They got an interim injunction against persons unknown, and they wanted to proceed to summary judgment, but the injunction was discharged. And the various problems were, there was no service on the persons unknown, so they weren't brought before the court, before the final order. The summary judgment was going to include a class of people who actually weren't doing anything wrong. And the Court of Appeal held that in this protester's case, the final injunction could not bind newcomers. It couldn't bind new protesters who turned up after the final order had been granted. So very much on the same sort of lines as Cameron, but in a different circumstance, Court of Appeal recognized the distinction between interim and final relief, and in particular, that final relief can only bind those people who are in front of the court and parties at the time it's handed down. Interim relief, quia timet injunctions, does lie against newcomers. The order can be brought to their attention. They can join the proceedings whilst they're still going. At the end of that case, the Court of Appeal issued a warning, and they said that the claimant was seeking to use private law remedies to prevent public disorder. He pointed out that this was not a suitable use of such a blunt tool.
So what, Michael, in short, what were the important aspects of the cases before him?
Yes, well, this is the points that Mr. Justice Nicklin was identifying as matters of concern in the various cases in front of him. He had 7 of them, but I mentioned 4 in particular because they come back and they're important to the end of his decision. First of all, in nearly all the cases in front of him, there had been a distinctly lax approach towards service, towards whether that happened at all, or if it did happen, complying with the formalities of it, or if applications for service by an alternative method were made, whether those were made in a proper way. That's the first point. Secondly, there was by and large inadequate descriptions of the persons unknown in the claim form. I've mentioned the distinction above between the man who stole my iPhone and the man who's around the corner. It fell on the man who stole my iPhone side of the line. Thirdly, very heavily frowned upon the use of interim applications court in the Queen's Bench Division. They very much did not want these applications to appear in that court. They were rarely sufficiently urgent, and rarely did the court have enough time to deal with such applications. And then the fourth is that there was, by and large, a failure to progress claims after the interim injunction had been granted. And the result of this was that local authorities were able to rely upon the rule that interim injunctions against persons unknown work, but final injunctions don't. So if you have a perpetual interim injunction, you've achieved what it is that you want, but you haven't progressed the claim. So those were 4 matters of particular that concerned Mr. Justice Nicklin. Then he dealt with the issues Now, the first issue, I'll remind you, was can the court revisit a final order? And as we know, the court usually can't revisit a final order other than on appeal. But in these cases, the court did in two situations. First of all, some of the orders provided expressly for the court's jurisdiction to continue. So a final order might have said a newcomer to the site has 72 hours to apply to the court. By definition, that person can get before the court. I would say in passing, that's a little bit of a tell. If a final order has that, it really looks a bit more like an interim order than a final order. So that's one respect in which the court had jurisdiction. The other, he said, is as a matter of course, if an order on its face says that it can apply to newcomers, people who weren't originally parties, then inherently that must be reviewable on the newcomer's application. So we come to the key issue. Could a final injunction in a traveller's case be binding on newcomers to the site, or could a contra mundum order be made? In relation to newcomers, you won't be surprised to hear from what I've been saying earlier, the answer is no. And the essential problem was one that I've already referred to. It was the Cameron issue. Newcomers have not been brought before the court's jurisdiction. They're not bound as parties to the proceedings, and they're no different to the protesters in Canada Goose or the unknown driver in Cameron. Even though the facts are totally different, the fundamental approach towards civil procedure is the same. And the crucial difference between interim and final injunctions was explained and illustrated rather well by the case called South Cambridgeshire and Gamel. Now, in that case, an injunction was granted, and I'm going to use the precise words, against persons causing or permitting hardcore to be deposited and or to station caravans, mobile homes, or other forms of residential accommodation on land to be occupied at Victoria View, Smithy Fen, Tottenham, Cambridge. Now, this was a sufficient identification of the people because it told you where they were. And so when that interim order was made, once someone came onto the land after the order was made and its terms were communicated to her, she was guilty of breach of the order and contempt because she answered to the description of the defendant. She was a person unknown. She was a person with her motorhome at Victoria View, Smithy Fen. And of course, that meant that she was able, as a party to the proceedings, to come before the court and make her case, and she'd be bound by any final injunction. In passing, there are other examples of interim orders which bind non-parties. Those are non-disclosure orders. Third parties who know about that are prevented from doing acts which may affect the administration of justice. But this doesn't work for a final order in a traveller's case. So Mr. Justice Nicklin realised that this would wreck the little cottage industry of travellers' injunctions, but there was no difference between them and the other cases. They were going to be affected. They were going to be governed by the same rules, and they couldn't be granted. Another point he made was that in reality, what people were trying to do was to get in rem relief, to try and prohibit conduct generally, rather than to go against individuals. That was not permissible. So he therefore applied the conventional approach towards non-parties from the road traffic case in Cameron and the protest case in Canada Goose to take the teeth out of traveller injunctions.
So where does that then leave contra mundum?
Contra mundum. Now, it was an example of one of these from one of the cases, and the order said, it is forbidden for anyone to. That's an order against all the world. Now, the courts can make such orders, and the jurisdiction was established in the case of Venables and the Times. He was one of the boys who killed Jamie Bolger, and he was allowed anonymity. So an order was made preventing anyone from disclosing that. These are a very rare and exceptional form of case, and they only arise when the court has to intervene to prevent a real and immediate risk of serious harm, such as would have been to Venables if his identity was disclosed. And the interests of the residents in the localities against the travellers did not match that of people like Venables, and particularly where there was a balance of the interests of the travellers who have their own convention. So contra mundum didn't lie. The final two issues, which I can mention very quickly. The third issue, since a final order doesn't ban newcomers, it's essential for the persons banned to be identified. And the fourth issue, Mr. Justice Nicklin was a bit worried that one might get perpetual rolling applications for interim relief to take advantage of the different characteristic of interim relief. But he decided that was not likely to happen because any courts now on being asked to grant interim relief will be looking forward. Is there a risk of harm? Will there be identifiable people who can be caught by a final injunction? And if that's not the case, and it looks like an attempt at a general prohibition on behaviour, they won't get the interim injunction.
So what are the lessons to be learned, Michael?
What are the lessons to be learned? Well, Mr. Justice Nicklin gave his own detailed guidance for future applications, which people need to look for. And in his closing remarks, he said this: there are grounds to suspect that in a significant number of applications for interim injunctions, there were material and serious breaches of the procedural requirements and procedures of the court. This included, as I've mentioned, allowing interim cases to go to sleep after interim injunctions. He went on, I will ensure, so far as possible, they will be properly investigated. So the lesson seems to be, if you've got what looks like a practical, common sense approach to dealing with an occurring problem, which the rules look like they block, and can only be circumvented by a sort of utilitarian approach towards the rules, and forgetting a few fundamental principles of how normal cases are run, you might have a career-changing opportunity. But the chances are that the career change may not be all for the good, because I would not like to be one of those people being investigated about that. Now, that has, I think, taken up my time. I was very quickly going to mention a case called Aster Communities and Chapman, which is a dispensation case, tenants achieving dispensation of failure to comply with the consultation requirements. That simply held that if one tenant out of hundreds would have made an objection in the process, all the others can take advantage of that sole injection. And also to mention that there is a forthcoming leasehold reform ground rent bill passing through Parliament, which will restrict residential long lease rents granted after the Act is passed to a peppercorn. There's various aspects about how the Act applies. It's a fairly straightforward Act, but those were the two other matters I wish to mention.
Thank you, Michael. We just got just a couple of questions which we can do just probably in the time available. And these are just for Adam. It's been asked, would the case on frustration have been stronger if the lease had come to an end during the COVID restrictions?
The Master sort of hypothetically considered that issue, and he suggested in his view that it may well have made a difference. I think it's fair to say it's a relevant factor, but I mean, the general approach is you sort of look to what one takes the bargain to be at the time that the lease is concluded. Then one looks at the alleged frustrating event and considers whether that event makes the position radically different from what it would have been considered to be at the time of the conclusion of the lease. So I suppose it's fair to say that that is a factor of relevance to that consideration. In some cases, it will be of greater relevance than others. I mean, I suppose one could take an example of a 50-year lease. It just has six months left to run at the time of the COVID-19 regulations. I suggest in that sort of context, looking at matters at the time the lease was granted, but would those 6 months of non-use make the bargain radically different? I'd have thought not. I suppose going to the other limb of extremes, if you have say a 6-month commercial lease, they've only been in occupation for 1 week, then the COVID-19 regulations come in and it terminates during the course of those regulations. That's probably a stronger case, or certainly a stronger case.
And so just following on from that, you mentioned that the familiar test that a contract may be frustrated if something occurs during the life of the contract, which renders the performance of the bargain radically different from that undertaken when the contract was concluded. So what then? I think somebody's asked what can be looked at to assess what bargain was undertaken when the contract was concluded. Is it just not the terms of the contract?
No, that's right. Yeah, I mean, well, certainly, I mean, what the contract's one thing to look at, and then possibly the major thing to look at, and you look at the contract in the usual way and in its factual matrix. But I think it's fair to say it's now established that one does also look to wider considerations. I think the key purpose for doing so would be to try to ascertain what was the actual sort of initial bargain between the parties at the time the contract was entered into, so that one would look at mutual understandings between them, and again applying an objective basis. That's set out quite clearly by Mr. Justice Marcus Smith in the EMA case a couple of years ago, now the European Local Agencies case. I think, I mean, previously there's adoption of thought that, you know, frustration is all about construing the contract, so you never look beyond any matters relevant to construction. I think it's fair to say that the court's now prepared to look at wider considerations, as I just mentioned.
Thank you, Adam. Well, I think we're at the end of our allotted time. I think just to say thank you very much for attending this morning. The next webinar will be in June, and we will be confirming the date and details shortly, and Emma Broom will be doing that. So please just look out for the advertisement, and we look forward to seeing you all again next month. So thank you very much.